Friends, today we are going to deal with a very important topic which is uh, daily we touch the area that is called bail. In recent judgment, Supreme Court given certain directions and certain guidelines regarding granting and not granting of the bail. When bail should be granted, when bail should not be granted. A very important guidelines and directions and category of bails and offences, not bails, category of offences also given by Supreme Court in this judgment, and direction also given all central government, state government, union territories, high court, district court, including trial courts, so that all JCJ aspirants, junior civil judge aspirants, and practicing advocates, law students, including citizens, must know about this judgment. Okay, in this video, now I am going to cover the just directions given by the Honorable Supreme Court regarding bail. Another video, I will cover the categories of offences and how the court should deal with bail application relating to that offences. Okay, come to directions. What are the conclusions and directions given in this judgment? The judgment name is Satender Kumar Antil versus CBI. Satender Kumar Antil versus CBI 2022 judgment. You can straight away type Google Satender Kumar Antil, it will come. Okay. So, by keeping all the importance of the bail, personal liberty, Article 21, and the previous judgments, the Honorable Supreme Court has given central government direction to central government that a separate enactment should be done regarding granting of bail, like United Kingdom and other countries. You know that in some countries there is an act, but particularly dealing with the bail. So, in that way, Supreme Court directed the central government to make a separate enactment in the nature of Bail Act for what? To streamline grant of bails. For grant of bails. The Supreme Court, it is in the opinion that bails should be granted liberally, subject to other conditions. So several persons are not being released despite their eligibility to get bail. So by taking stock all the facts, all the judgments, and all the statistics prevailed in India, this judgment has been come. So the first direction is central government has to create and separate enactment for bail. That is one direction. The next one is, in this judgment, as already I told, directions given to several institutions. Now, the second, that is B, the B guideline is investigation agencies. This direction is for whom? This direction for investigative agencies, IO. This is regarding section 41 and 41A. This is well known, already it is well publicized. So, all investigative agencies and officers should take care the mandate given in section 41 when arrest should be can be done without warrant and 41A notice. So we know that what is the mandate of 41, what is the mandate of 41A, how to comply with the notice under section 41A, when 41A has to be given, and what is the procedure, and everything. It is a separate topic. We know the guidelines in Kumar judgment also. So the Supreme Court directed the investigation officers and the agencies, they should comply with the 41A. If any dereliction is there, it should be reported to higher authorities and take proper action, appropriate action. This can be done by court. Who has to give complaint? Complaint has to be taken by the court, followed by appropriate action. This is regarding section 41 and 41A. Next, there is another direction. You can say this C. Another direction is to court. What is the direction to court? How to, by the compilation of section 41A, in satisfaction, court has to satisfy about the compliance of section 41A notice. As Kumar judgment mandates, the procedure should be followed. If 41A procedure not followed, the court can grant bail to accused. That means non-compliance of 41A procedure enable the accused to release on bail. So this is direction to court. Next direction to state and central government. This is regarding what? This is standing orders. So 41A notice, what happens in some states, because of the supreme insistence of the Supreme Court, police are just formally complying with 41A notice, but there is no proper way while issuing the 41A notice. Sometimes they may issue 41A notice all of a sudden, and all of a sudden they may arrest him. To show that they complained 41A notice, just they put the notice 41A notice in hand, and then and there the police will arrest the accused. These are several distortions are there while complying with the 41A notice. So to avoid all these things, Delhi High Court, in fact in WP 7608 of 2018 has given a detailed directions and a procedure to comply the 41A. To that effect, the investigating officers have created a standing order 109 of 2020. So, by noting this Delhi High Court judgment, by noting this standing order 109 of 2020 for complying of the mandatory 41A procedure, all states and central union territories has to make such standing orders, has to make such procedures for properly complying section 41A notice. So this is another judgment. Next, this is the fifth one. This also direction to court. What is this direction? If you see section 88, section 170, section 204 and 209 of CRPC, these are the occasions where the accused has to be produced before the court by arrest. So, arrest is necessary in these occasions. What is that? Section 88. This is regarding issuance of summons, warrant, and such situations. So, in such a situations, arrest is a mentioned in that. In the same way, 170 of CRPC dealing with the producing the accused before magistrate after completion of the investigation for filing what do you call charge sheet or after taking cognizance. So, in such a situation also, arrest has been mentioned, custody of the accused has been mentioned. Next, 204 and 209. These are also occasions which mention the custody of the accused. So that in these four occasions, arrest, the separate need not be insistence of separate bail application. In sometimes what happened, courts are not granting bail, not releasing the accused on the ground that he has not filed any bail application. So, in several judgments, Supreme Court and High Courts held that in such a cases, separate bail application is not necessary. Next, judgment. Next ground, judgment of Siddhartha judgment is there. What is this Siddhartha versus? There is a judgment, a landmark judgment regarding section 170 CRPC. A detailed analysis has been done. So, in the judgment, Supreme Court Siddhartha heading name, Supreme Court held that there is no need of making separate bail application for releasing of the accused. So, in this judgment, Supreme Court directed the courts to follow the judgment of Siddhartha regarding 170 CRPC. So, this is another direction. The next one is special courts, state and central government. So, earlier I have stated that Siddhartha versus state of UP. So, you can type that. Next, state and central government directions given regarding special court. You know that Prevention of Money Laundering Act and UAPA Act and NDPS Act, there are special acts. In these special acts, stringent provisions are there regarding granting of bail. Normally, they won't allow for granting of bail in normal, ordinary conditions which are available in other statutes. So, special courts has to be established to deal with these offences for special acts. For that purpose, the Supreme Court directed the central government and state government to comply the directions issued by the court from time to time regarding constitution of special courts. That means what? When there is a requirement of constitution of separate court through separate act, they have to constitute. For that, any High Court or Supreme Court directed from time to time to create such special courts, that state government or central government has to create such a special court. Normally what happens, they design already situated courts as a special court and leave it. So what happens? Burden of work is there on the judges. Then delay may be occurred. To avoid that delay, to avoid burden of work to the presiding officers, special courts should be constituted. If there is any direction from the higher courts, state and central government has to follow. And there is a direction to High Court also regarding the special courts. Regarding filling of the vacancies, when special court is there, sometimes there is no special court. Suppose if there is a special court, no presiding officer. So in such a situation, High Court has to done exercise in consultation with the state government to fill up the posts of vacancy posts of the presiding officers of such special courts to take fill up the post expeditiously. Next, another direction to High Court regarding what? How many under trial prisoners are unable to comply with the bail conditions. Suppose if bail is granted with conditions, but under trial prisoners are unable to comply that bail conditions, they may remain in jail. In such a conditions, such a situation, High Court has to undertake an exercise to find out how many under trial prisoners are there and what is when they fail, and accordingly to take steps to section 440 of CRPC for releasing of the bail. After finding out that under trial prisoners are unable to get to comply the conditions of the bail, then they have to follow the mandate of section 440 CRPC. What is the mandate of section 440 CRPC? 440 CRPC maximum says that bail bond should not be excessive. Bail bond should be suitable to the conditions of the accused and the case. So 440 is very liberal regarding the granting of bail. I will read that 440 for your benefit. So it mandates that it should not be excessive. The amount of every bond executed under this chapter shall be fixed with due regard to the circumstance of the case and shall not be excessive. So shall not be excessive. By taking this 440 mandate, the High Court should take steps to release the accused. The another one is sureties. 440 has to take into consideration. Next, section 436A. 436A. What is section 436A? Maximum punishment. Maximum, not punishment, maximum sentence he should undergo in jail as a pending investigation, pending trial, pending inquiry. Suppose 10 years punishment is maximum. He is in jail beyond 5 years. Trial has not been completed. Investigation, trial or inquiry is pending. In such a situation, 436A come into rescue and he has to be released. Except death case. Death and otherwise provided by other statutes. So, this 436A has to be complied strictly. Who has to take care? This has to be taken care by High Court. This has to be taken care by High Court. With regard to this 436A, there is a landmark judgment by Honorable Supreme Court that is called Bhim Singh. That is called Bhim Singh case. So, what is the direction in this case? Satender Kumar Antil case, what is the direction to High Court to conduct such exercise? How many persons have been already served the sentence of half of the maximum punishment? Half of the maximum punishment. In Bhim Singh case, what Supreme Court told, all the judicial magistrates, chief judicial magistrates, to conduct a sitting in jails itself weekly once and find out how many persons crossed this half of the maximum punishment, and then and there the magistrate has to pass orders. For that, jail authorities has to cooperate. Such directions are there. Still, if any such persons are there, it has to be taken care by High Court. This is another direction. Next, bail and anticipatory bail. Regarding this bail and anticipatory bail, disposal of the application. When, how many, what is the maximum period, within that period all courts has to be disposed the application. For disposal of the bail application, what is the maximum time limit? So even bail applications are kept pending for months together. So that is bad. For that, Supreme Court held that if it is a regular bail, maximum time is 2 weeks, except intervening application. Suppose any intervening applications are there. What is the intervening applications? Who filed the intervening applications in bail cases? Normally victim. Now, 2022 there is another judgment. According to that judgment, victim has all rights to make his argument to be heard at all stages, so that victim can file intervening application opposing the granting of bail. Except that situations, in all other situations, the regular bail application shall be disposed of within 2 weeks. If that is the case of anticipatory bail application, it should be within 6 weeks. It should be disposed within 6 weeks, except intervening applications. So there is a time limit now to dispose of the bail applications. So last one is the all state and central government has to comply with these directions and file their status report within 4 months. So these are the important conclusions and directions given in Satender Kumar Antil versus Central Bureau of India. This is very crucial everyday who is practicing and who is appearing for exams. Regarding categories and guidelines, I will take another video. Thank you.